Hello everyone, good morning. Today is 25th of March and I welcome you all at the Hindu newspaper analysis discussion. So guys, let's start with the video. And in today's video, we are going to discuss entire analysis of Hindu newspaper along with all the background and the way forward in articles that are important for our examination. So guys, today we are a little bit late. The reason being that I had classes since 8 in the morning and I have just reached back home after the classes. So now we are recording, now we are having this live session. So apologies for that particular thing, and even the Hindu newspaper also got published little bit late today. So otherwise I could have streamed the video live right in the morning as we did yesterday and we usually do. Okay, now starting up with the newspaper. First of all, let's see overview of newspaper and let's try to understand that which articles are actually important in the today's newspaper, and then we will one by one be taking up all those articles. So first article guys, here we can see that the opposition MP Mr. Rahul Gandhi has been disqualified as MP. Okay, now understand that in this particular article there are two type of dimensions that will open up. One is a political dimension, that this is an attempt by ruling party to have a kind of an absolute power, and that is one is constitutional dimension. So political dimension is not important for our examination and we will not be going in that, but constitutional and academic angle that we have here, we will see that little bit. Then further moving on this line we have a article in editorial section as well. Then guys, we have these advertisements etc, not important for our examination anyhow. Moving on, then we have these political articles, again not important for examination. So guys, directly we will move, and then again a lot of advertisements have been given. Okay, after that moving on guys in this particular direction, fine. Here we see after Varanasi government to organize the Tamil Samagam in Saurashtra and Uttarakhand. So we will see this Kashi Tamil Samagam that was organized earlier. So it is a part of Ek Bharat Shresth Bharat. We'll take this particular article. Then further moving on guys, after that again these tenders and advertisements and all these notices are there. Coming to editorial page, why Tipu Sultan must be killed again. Okay, now guys, when we talk about this particular article, so the article has actually been written in lot of literary kind of undertone. Article doesn't contains much of academically relevant and academically important substance. However, if you want to read for interest or leisure, you can do that particular thing. Rahul Gandhi's conviction, will see the Representation of People Act, a chilling remark, to and the price to pay. So this article talks about the recent statement by the law minister where it has been said that some of the judges are acting in an anti-India manner. We'll see this particular article. No cause for alarm. People of vulnerable group must take all precautions against COVID-19. So guys, we see this particular thing that now newer variants of COVID-19 virus, SARS-CoV-2 virus are coming up, okay, which actually incites some anxiety. But it has been said that we need to take precaution and vaccine. That is the only solution for this particular thing. Then further moving on guys in this direction, we have this ground zero report changing scenario on the cards. Doesn't contains much of relevant substance. So we will move. 14 opposition parties move Supreme Court against misuse of ED CBI. Political dimension will avoid, but we'll see that what is the relevant issue that comes here in this particular direction. Then further moving on, after that India failed to create positive impression among businesses moving away from China. We'll take this particular article. Then moving on guys, after that here AAP, Trinamool and all these political issues have been given. No need to go too much in detail in this particular direction. Member of banned outfits is a crime under UAPA. We'll see this particular article. Then guys, ICMR releases ethical guidelines for AI usage in healthcare. Now guys, understand this particular thing. Here it has been provided by the ICMR that artificial intelligence is now being used in governance. Artificial intelligence is now being used in the healthcare. In this particular direction guys, basically the document has been released which largely focuses on that the artificial intelligence should only be used for the welfare of the people. Just as an example we can cite it. Then further moving on, penalty for failure to protect Ramsar sites. So two of the Ramsar sites have been mentioned, we'll take up here. Then guys, after that further moving on, we come to the world page. Macron under pressure as a scores injured in protest. Okay, so guys, here we see this particular thing that the violent protests have been carried on in France, but the article is not very much important because for our examination those articles are important which will have some substance which will showcase how India is getting impacted. Fine, China says it does not ask companies for foreign data over the TikTok. Fine, then again Russia-Ukraine war going on. G20 sees inflation as sticky to extend policy tightening. Okay, and then guys, we have largely these political trends, etc. Lok Sabha approves setting up of GST appellate tribunal. Now we'll see this particular article with respect to examination, and then we have this sports page. So this is overview of the newspaper, and now guys, let's discuss all the relevant articles one by one in detail. Okay, so guys, in every class we start with the GS quotation, and this particular quotation can be used to complement our answers in GS paper number 1, 2, 3, and 4. Just a minute. Okay, so today we'll take the quotation from Wes Fessler. Wes Fessler. So Wes Fessler says, good men are bounded by conscience and are liberated by accountability. Now, every person has to be bound. There needs to be certain limits that what can be done and what should not be done. Now, basically how those particular limits are defined. So those limits are defined by the voice of conscience. Your voice of conscience guides us that this should not be done and this should be done. So the good men, the ethical men, they are always bound by conscience. They are not bound by external pressures. They are bound by internal pressures, that is the voice of conscience, and liberated by accountability. When they have an opportunity to answer about their actions, when they have an opportunity to answer about their conduct, they feel liberated. Okay, so accountability gives them an element of liberation, whereas unethical people, they will feel burdened when they have to furnish accountability, but good men feel empowered when they get an opportunity to furnish their accountability. Very good quotation, and can be used in GS paper number 4 ethics. GS paper number 4 ethics. Fine. Now moving on, guys. Sir, have one doubt. Can go to tag plant. Cultivate another. Krishna, I am not able to understand what you are trying to ask. Please write again. Now moving on and taking up, guys, the first article for the today, which happens to be a very important news for today. And guys, here what we are going to take, we have clubbed two articles. One is this from first page, and then there is one more article that has actually come in editorial page. Okay, that is a chilling effect. And in these two particular articles, we are going to understand that what led to the conviction, what led to the disqualification of a sitting MP from his seat. So this issue we'll see with respect to the GS paper number 2, issues related to the polity. GS paper number 2, polity. Now, so as we talk about, guys, this particular case, so Mr. Rahul Gandhi was charged of defamation. Now the provisions of defamation has been provided under IPC section 499 and 500. So right to reputation has been recognized by Supreme Court. And if I say certain words by which I am trying to defame, I am trying to malign a person's reputation, a person can file a complaint, a case against me under these section 499 and 500 of IPC. Now Mr. Rahul Gandhi around 2019 had made a statement where he had made certain remarks on Prime Minister. So under that particular thing, a case was filed, and a Gujarat court has now found Mr. Rahul Gandhi guilty of defamation and has given him 2 years of punishment in jail. Now immediately the court has not asked Rahul Gandhi to has not immediately that particular jail sentence has not come in effect. This jail term is suspended for 30 days. Within these 30 days, Mr. Rahul Gandhi can appeal to the higher court against this particular conviction. Now, up till yesterday, there was a doubt that as 30-day suspension has been given, so will the disqualification of Rahul Gandhi be happening immediately, or will it a little bit be delayed, or what will happen? So here we see that Lok Sabha Secretariat has finally issued a notification, and as per that particular notification, they have said that Mr. Rahul Gandhi stands disqualified from his seat of MP from Wayanad. Now, what are the provisions that have been used here? Let's try to understand these particular provisions. So basically, guys, as we talk about the disqualification from the Lok Sabha, So for that particular thing, we have article number 102 of Indian Constitution, and also there is section number 8 of Representation of People Act 1951 that is there. So both of these particular sections have been read, and as per that the disqualification has taken place. Now first of all, when we talk about the article number 102 of the Constitution, it provides certain conditions in which the MP, member of parliament, can be disqualified. Now what are the conditions that it provides? Let's see all these particular conditions one by one. So basically it provides that an MP will be disqualified, number one, if he holds any office of profit under the government of India or any government of state, or other than the office declared by the parliament. Fine. B, that if he will be disqualified if he is of unsound mind, if he is of unsound mind, mentally not stable, if he is undischarged, insolvent, okay, if he is not a citizen of India or has voluntarily acquired the citizenship of any foreign country, or see this particular condition, if he is disqualified by or under any law made by parliament, if he is disqualified under a law made by parliament. So parliament can have a different law, and under that law can specify the conditions. Now understand this thing. For elaborate conduct of election process in India, disqualifications in India, parliament has actually passed two laws: Representation of People Act 1950 and Representation of People Act 1951. Now what has happened, when we talk about this Representation of People Act 1951, this is a law, and under this particular law there are certain disqualifications that have been imposed, and on the basis of those disqualifications mentioned in the Representation of People Act, Mr. Rahul Gandhi has got disqualified. Let's understand that what are the grounds of disqualification mentioned under the Representation of People Act. Let's discuss these grounds of disqualification that are there. So basically, there are different sections that we have. Now, when we talk about the Representation of People Act, it was introduced by Dr. B.R. Ambedkar to ensure that only the people of highest ethicality and morality are the ones who are entering in the parliament. So this particular thing, this particular provision, this particular law was brought. Now, first of all, guys, we have section 8 subclause 1. Section 8 subclause 1. Now it disqualifies an MP if MP has been convicted that he is responsible for promoting enmity, promoting hatredness between two of the groups. Then he can be disqualified. If he is found to be involved in an act of bribery, then he can be disqualified. If he is under, if he has carried undue influence, if he has tried to influence the elections, or has carried personation, have tried to have carried personation of some another person. Okay, suppose I am Mr. A, but I show myself as Mr. B, that is personation for some other person. So then the person can be disqualified. So this provision is not applicable in the case of Mr. Rahul Gandhi. So his disqualification has not happened under section 8 subclause 1. Now you need to guys see the Representation of People Act carefully. Why? Because there is guys directly the Representation of People Act that has been mentioned within our GS paper number 2 syllabus. Okay, then second is section 8 subclause 2. Section 8 subclause 2. Now this particular thing provides that a person can be disqualified if he has been caught in if he has been caught with an offense dealing with holding or profiteering or adulteration of food. Okay, if you have hoarded the potatoes, onions, the food which should not be hoarded, if you are hoarding of the food, if you have carried any adulteration of the food, or if a person has been convicted for at least 6 months, if 6 months have been convicted for a 6-month punishment under the Dowry Prohibition Act. If a person was taking dowry and has been caught under that and has been convicted for 6 months, then the person will be disqualified. 8 subclause 2. Now obviously this provision is also not has been applied in Rahul Gandhi's case. Now coming to the third provision, that is the section 8 subclause 3. Now section 8 subclause 3 guys also has one more category. It provides that a person, if he is convicted for any other crime, there are certain crimes that are mentioned in 1 and 2. Apart from 1 and 2, for other crime, if a person has been convicted and if a person has been given a jail sentence of more than of 2 years, Okay, if a person has been convicted of an offence and sentenced to imprisonment of for not less than 2 years, then a person will be disqualified and will stay disqualified for a further period of 6 years since his release. Let's say a person gets convicted today for 2 years, so immediately he will be disqualified for 2 years and after release for next 6 years. So this will be the conviction, and this is the provision under which Mr. Rahul Gandhi had got disqualified, section 8 subclause 3. Okay, this is something that has happened. Now guys, basically it is being said that there is a kind of a political undertone to this development also, but we don't need to go in that particular direction. Now what has happened, there is also one more provision that was earlier there which could have given the protection to Rahul Gandhi, but that particular provision doesn't applies now because it has been removed by the Supreme Court judgment. Let me explain you that particular provision that was there first of all. So there was this provision, that is section 8 subclause 4. Section 8 subclause 4. Now this particular provision very clearly provided that if a person has been convicted, then for 3 months the person will not be disqualified. Why for 3 months he will not be disqualified? Because a time was given that within 3 months a person can file the petition in a higher court. And when the higher court will be giving the decision, then that particular matter is to be decided. So 3 month grace period was provided that you file a petition in another court and then that court will take the matter. But what has happened, this particular provision section 8 subclause 4 has been removed by the Supreme Court in Lily Thomas versus Union of India case. It has been said that this section 8 subclause 4 is actually unconstitutional. It is actually unconstitutional. It will promote more criminalization of politics, because we know this particular thing that how judicial system, how much slow it is in our country. So a person convicted for a crime, for within 3 months he will appeal in some other court, then that case will go, then another court he might appeal. So basically it is actually providing an immunity. So this section 8 subclause 4 actually got removed after the Lily Thomas versus Union of India 2013 judgment. So this provision will not be able to provide any protection. Okay, then further, this is all about guys this particular article. So I hope that you have understood it. Okay, I hope guys that you have understood this entire issue. Moving on in this particular direction, there seems to be he doesn't get disqualified because of the verdict. The verdict came in order to make him disqualified like that for just a sentence, 2-year imprisonment. Now moving on in this particular direction, the next article, a chilling remark. A minute guys. Okay, a chilling remark and the price to pay. Now this particular article guys is actually talking about that recently certain remarks have been made by minister. Okay, remarks have been made by the minister, union law minister, and these particular remarks actually are not reflective of a healthy commentary or are not reflective of a healthy dialogue in a democracy. First of all, let's see this particular thing. Now you are not required to go too much into detail in this particular article with respect to the examination. That type of substance is not there, but briefly I will cover that. So basically what has happened, the union law minister has recently described the few of the retired judges as well as some activists as an anti-India gang, and it has been said that the judiciary is actually today playing the role of opposition party. So many of the judges after their retirement, they had made certain comments against the government's policies, but it is being said that it is unwarranted. It should not have been said by the judges. Now the article is saying this particular thing, that when we talk about the judges who have got retired from the judicial office, after the retirement they don't cease to be the citizens of India. They are still the citizen of India, and they have all the right that they can take an active participation in the policies of governance that are going in a country. So this is not a correct thing that because of their remarks they have been called as an anti-India gang. This is not correct. This is something that has been provided. it is saying that they have not given their fundamental right of free speech and expression in return for the pension that they are actually drawing, the pension that they are actually getting. Okay, so such kind of things are not good, should not have come out of that. So this is all which has been carried in this particular article. Not needed to go too much in detail with respect to the examination, guys, as I have told you. Now moving on, after Varanasi, government to organize Tamil Samagam in Saurashtra and Uttarakhand. Okay, so guys, we'll see this particular article with respect to the examples of cultural integration, examples of cultural integration that can be used in GS paper number 1 as well as GS paper number 2. Now, first of all, India is a big nation having a lot of diversity, and as we have diversities, we have different lifestyles, as we have different perceptions towards many other things. Often these differences become a ground for differentiation, and that ground for differentiation often becomes a ground for division. And in order to avoid that particular thing, we need to have cultural integration so that the feeling of oneness comes in us. Now government on this particular direction is already running a scheme, that is Ek Bharat Shresth Bharat. Now under Ek Bharat and Shresth Bharat scheme, the cultural exchanges happen between the different states. For example, students of Jammu and Kashmir, let's say, will be visiting Madhya Pradesh. Students of Madhya Pradesh will be going to the Jammu and Kashmir, where they will try to learn each other's culture, they will try to learn each other's value, and will be able to know each other in a better way. Now what has happened recently, government actually within the Ek Bharat Shresth Bharat came with the Kashi Tamil Samagam. Kashi Tamil Samagam. Now Kashi, it is the ancient name of Varanasi. What was this Kashi Tamil Samagam? The people from Varanasi will be, or the people from North India, particularly the Varanasi, will be going to the Chennai, Tamil Nadu, and people from Chennai will be going to the Varanasi, so that they can come to know about each other's culture. And that was called as an attempt to bring a cultural integration in India. So Kashi Tamil Samagam already happened, and on the success of Kashi Tamil Samagam, now government has decided that there are more editions of such exercise that will be brought. So now what government is planning? Government is planning that now, first of all, Saurashtra Tamil Samagam will be organized. Fine. Now Saurashtra Tamil Samagam, where people from Chennai or Tamil Nadu will go to Gujarat, and people from Gujarat will go to Tamil Nadu. So Saurashtra Tamil Samagam, and after the Saurashtra Tamil Samagam, there is Kedarnath Tamil Samagam that will also be observed. And in Kedarnath Tamil Samagam, what will happen? People from Tamil Nadu will be visiting the Uttarakhand, will get to know about the spiritual, spiritual heritage of Uttarakhand, all such kind of things. So this is something which government is going to plan. Now guys, when we talk about the Kedarnath, it happens to be one of the most sacred shrine, as we have these Char Dham, 4 shrines. Out of those Char Dham 4 shrines, Kedarnath is one. And also when we talk about the Kedarnath, okay, when also when we talk about the basically, just a minute, Kedarnath, fine, situated on the banks of Mandakini, okay, and it is also the one Jyotirling out of the 12 Jyotirlings that are there. Okay, so this is something that's going to be there. Now further moving on, Lok Sabha approves the setting up of GST appellate tribunal. Lok Sabha approves setting up of GST appellate tribunal. Now, basically guys, as we talk about listen, what is happening right now, the budget session was going on. So every year government come with the budget, and basically along with the budget, government also comes with certain amendments into the tax structure, certain new schemes, certain new proposals are introduced. So when these proposals of the budget are to be implemented and these new proposals are to be implemented, government has to pass a finance bill which gives effect to all these proposals. So what has happened, just yesterday, Lok Sabha has passed the Finance Bill 2023, which was brought after the budget. And here, government has finally created much awaited GST appellate tribunal. GST appellate tribunal. Now, guys, you might already be knowing that GST fine has replaced the indirect taxes in India. Okay, and since the GST got implemented, there are many of the disputes, tax related disputes, matters that are there. Now, up till now, guys, with respect to the tax disputes, fine, people did not had any avenue that if there is kind of a dispute where they can go. And what actually happened right now, the taxpayers, if they are not happy with any of the provisions of the GST, then they have to move to the high courts. They have to move to the high courts. And you know that there are a lot of pending cases in the high court. First of all, it burdened the high court, and at the same time, a resolution was also very much delayed. Okay, and as we talk about the indirect taxation matters, largely they concerns the business enterprises, and therefore ease of doing business of India was also getting impacted because cases were taking a lot of time to be cleared. So therefore, now what has happened? Finally, the government has notified, yeah, has notified GST appellate tribunals, where the pending cases in the GST regime, they can be lodged in this GST appellate tribunal. So this proposal has been cleared. Okay, so there will be the GST appellate tribunal, and there will also be the regional benches which could be operationalized. Fine. Now, moving to the next article. So guys, here we see 10 crore penalty on Kerala for failure to protect Ramsar sites. So basically, two of the important Ramsar sites have been mentioned here, which are very much important. And guys, now we have 75 Ramsar sites. Recently, what has happened in 2021 and 2022, 12 Ramsar sites have also got added to the list of Ramsar sites. We have 12 Ramsar sites. Two of the Ramsar sites are there in Kerala, which were not being which were not being protected properly, and 10 crore rupees penalty has been filed. Now, first of all, the National Green Tribunal. Now, when we talk about the National Green Tribunal, it happens to be a statutory body, okay, that is created by the law, and it is the apex tribunal for dealing with the environmental related matters. So, because of the indiscriminate pollution in the Vembanad Lake and the Ashtamudi Lake, Vembanad Lake and Ashtamudi Lake, the fine has been imposed. These are the Ramsar sites. Now, first of all, when we talk about the Ashtamudi Lake, you need to know that Ashtamudi Lake is called as Ashtamudi Lake because of its unique shape. Now, it is also called as the palm shaped lake. It is also called as the octopus shaped lake. And the Ashtamudi, the word Asht means 8, Mudi, braids. So there are the 8 unique curvatures in this particular lake by which the name comes. And when we talk about the Ashtamudi, it is one of the most visited backwater lake in Kerala, but it is not being protected properly. Now, further, we have Vembanad. Now, Vembanad happens to be the longest lake in India, which is there in the state of Kerala, and every year the Nehru Trophy boat race is conducted in Vembanad. Okay, so this is about it. Fine. Now, moving to next article. Membership of banned outfit is crime under UAPA, says Supreme Court. Fine. Now, UAPA stands for Unlawful Activities Prevention Act, and this particular act has largely been created to deter the acts which are committed against the sovereignty and the acts which are committed against the integrity of India. You might be knowing that there are many of such organizations which are promoting the radicalist ideologies, which are promoting certain of the separatist, which are promoting the separatist ideologies. And as separatist ideologies are being promoted, obviously they are going against the integrity of India. So these particular activities can be deterred. These particular people aligned with these the type of organizations, they could be deterred by using UAPA, Unlawful Activities Prevention Act. Now, what has happened? There are many of the people who have the membership of these unlawful activities. There are many of the banned organizations which are banned as per UAPA. There are people who have membership of such kind of an organizations. So, just having the membership of an organization which is a banned organization, does it make a person the participant in a criminal activity? Can you charge a complaint against a person just because he is a member of a banned organization? Now, earlier on this particular thing, there was a different position of Supreme Court. Supreme Court said earlier, no. Earlier, Supreme Court had given the judgment where Supreme Court has said that mere membership, fine, or now membership, but it is an inactive membership. Okay, active membership, then obviously it is a you can be charged. But if just a mere membership or an inactive membership is there of an unlawful association, it did not make a person criminal or it did not make a person a terrorist. This was the earlier ruling. Now what has happened? Now the Supreme Court has come out this particular thing that if a person is just a mere member of a banned organization, fine, even if he is not an active member, he is liable under the Unlawful Activities Prevention Act. We will assume that you are acting against the sovereignty and integrity of India. So now the Supreme Court has reversed its decision. Earlier it said that just a membership doesn't make a person terrorist, doesn't make a person an anti-national, but here say that no, even a membership, if it is there, a person can be charged under UAPA. This is the judgment that has come by Supreme Court. Supreme Court has further recognized this particular thing, that we have Article 19 subclause 4, which talks about the right to form unions, right to form associations. Okay, and you can join an association, you can join an organization, but at the same time, reasonable restriction can also be imposed. You cannot join any organization. Reasonable restriction can be imposed on this particular fundamental right. And sovereignty, integrity of India, protection of public order, protection of public morality, these actually happens to be the legitimate restrictions that can be imposed. Okay, so this is guys all about this particular article. I hope that you have understood it. Now moving to the next article. So the 14 opposition parties move Supreme Court against misuse of ED CBI by court. Now first of all, though, as of it, much substance is not there in this particular article, but let's see some of the trends that are emerging. Okay, so basically guys, many of the opposition members, they have said this particular thing, that they are being unduly targeted by the ruling government because of their different ideology, just because of them being the member of different political party. So it has been said that today what government has done, government is using the central agencies, government is using Enforcement Directorate ED, it is using CBI, Central Bureau of Investigation, particularly to target the opposition leaders who actually have expressed their fundamental right to dissent, okay, who have shown their dissent. Now here there are certain numbers that have been given. So it is being said that between 2004 to 2014, there were 72 political leaders that were investigated by CBI, and out of that 60% were from the opposition. But now what has happened, the opposition leaders that are being targeted by the CBI, that number has went to 95%. So 95% of the leaders that have been targeted, they are from opposition. Then further it is being said that when we talk about the Enforcement Directorate ED, now Enforcement Directorate is particularly takes up the matter related to money laundering, terror funding, etc. So ED also is investigating the opposition leaders. So before 2014, ED, the cases that were investigated were by the ED, 54% are the members from opposition. But today, 95% of the cases that are being investigated by the ED, they are the people who are belonging to the opposition parties. So it has been said that deliberately the opposition members are being framed. Deliberately, the opposition members are being framed, deliberately they are being targeted just because of the dissent that they have shown. So this is all about it, and therefore the Supreme Court need to intervene. Supreme Court need to intervene and need to issue the relevant directions that such misuse doesn't happen. Okay, then further moving on. Here, what the Supreme Court, these people have asked, they said that there should be a kind of a triple test that should be followed before ordering the arrest and remand. Now, number one, arrest by the CBI or arrest by the ED should only be made if there is a risk that a person might run away. Okay, or if there is a apprehension that a person might tamper the evidence, that you will destroy the evidence, or if a person can intimidate or influence the witness. So if a person can influence, intimidate the witness, can tamper the evidence, or can run away, then only these people needs to be charged under then only these people needed to be arrested. So just casually arrest should not be made. Is it clear or not? Why ED is not a constitutional body? Yeah, see, constitutional bodies specifically are only those bodies whose mention is there in the Constitution of India. So just ED is not mentioned in the Constitution, it's not a constitutional body. Fine. Then India failed to create positive impression among businesses moving away from China. Now we'll see this particular idea can be used in GS paper number 3. Now see this thing. Uh, as COVID-19 pandemic started, okay, as COVID-19 pandemic started, lockdowns were announced, and within the COVID-19 pandemic, as the origin of the virus was from China, there was a kind of a disdain, there was a kind of a little bit of a frustration also that was there against the China, and the countries realized this particular thing, that they have actually become a lot more dependent on China for their basic needs. In terms of the trade, they have dependent on China, become dependent on China, and countries started the decoupling from China. Decoupling means that they will ensure that their imports are not only coming from China, they want to diversify. Even the foreign companies, foreign investors who have come to China, they also started to move to the other countries. Supply Chain Resilience Initiative, SCRI, was started by Japan, was supported by USA also. So what has happened, foreign firms have started to move away from China. But if they're going away from China, where they will land? Where the next move is? Where the next destination is? So next destination is also the South and Southeast Asian countries. And many of these firms have actually landed in countries such as the Philippines, Vietnam, but not in India. Now see this particular thing. Now see this particular thing. So it has been provided that basically as the firms started to move away from China, these businesses did not actually landed in India. India was not able to take advantage of this particular China plus one strategy. So multinationals, they have shifted to other countries such as Vietnam, Thailand, Cambodia, Malaysia, but not in India. Now it has been said that actually today India's competitive position in the pharmaceutical sector, though we are referred to as the pharmacy of the world, though we are referred as the pharmacy of the world, but still we our but still active pharmaceutical ingredients are coming from China. What are API? See, whenever a drug is to be made, there is the base salt, which will constitute 80-90% of the volume of that particular drug. They are called as the API, active pharmaceutical ingredient. This is the base of any drug. They are coming from China. So though we are trying to become the pharmacy of the world, but even in that we are dependent on China. So we need to ensure the rationalization of direct taxes, indirect taxes, so that the international firms, they prefer to come in India. We need to promote the ease of doing business in India. Then only India can meaningfully attract them. Okay, so that is all, guys, in this particular direction. And now taking up the main practice question for today. So the main practice question for today, it reads: the state cannot plead helplessness in taking stringent measures for protection of environment and public health. In this context, discuss how the state government is failing to check the indiscriminate pollution of Ramsar sites in India. Fine, this will be the Ramsar. So this will be a 10 marker question for GS paper number 3. Okay, so that is all, guys, about it. Fine. So I hope, guys, that you have understood it, and I hope that you have enjoyed this session. So guys, that is all for today. And if you have liked the video, please do hit the like button. Please do comment. Now we'll be meeting on Monday. So till Monday, please take care of yourselves. Sir, is there any provision in Constitution that Rahul Gandhi gets immediate stay on this order? See, what has happened? One of an legislator from Lakshadweep also faced this particular thing. The person approached the Supreme Court. The conviction got stayed, but still the person has not been reinstated on the seat. So the respite can be given by Supreme Court. Fine. So that is all, guys, about it. We'll be meeting on Monday now. Till then, please take care of yourselves. Thank you so much.